Let's talk about, in today's news, and every Thursday we get the updated employment or unemployment numbers, and we added nearly another 3 million to the unemployment roll. And albeit that the numbers continue to shrink of the increase, we still have now almost 36 million unemployed. And there was an article in Kiplinger that talked a lot about the struggle to pay child support and alimony. We know that's real. We know typically when guys come to see us, I'm going to turn to you, Carly, guys really live paycheck to paycheck. And the question that many of them have is, we've been trying to talk about for the last 7 weeks or 8 weeks is really some tips. And I think Kiplinger was right to kind of go through this article. And I think one of the things that I have a question for you is really discovery. We've talked just a little bit about discovery in our past town halls, but why it's important to think about, one, your income and your ex's income too, because if she likewise is receiving a decrease, it may affect your ability to modify. And to maybe talk about how discovery can be used in that regard.
Absolutely, Scott. Great question. So whenever you file a motion to modify, whether you're modifying support alimony or if you're modifying child support, you're going to want information about not only your own finances, but what your ex is going through during this COVID-19 crisis as well. So issuing, even if it's just a few discovery requests, and discovery is just the legal process for getting information from the other side. So in Oklahoma, when you do a motion to modify, you can ask 30 questions under oath that she's going to respond to. So you can ask her questions about, is she earning extra income during this time? Was she on furlough? Did she get some sort of severance package? And getting all of that information so that you can use it in negotiations. And then if you end up going in front of the court, you can use that to present your evidence for your motion to modify.
Yeah, it's so critical, especially when, in child support modifications, which seem to be a little bit more straightforward. Michael, I want to turn to you. Whenever you talk about alimony, maintenance, or what we've often commonly referred to as spousal support, that tends to be maybe a little bit more difficult analysis, right? Because you have to pull out your judgment and determine whether it's modifiable or not. Maybe you can explain to guys really what they're looking for here and why that matters.
Sure, Scott. Once again, great question. I think when it comes to spousal support, as you probably discussed in prior panels, child support as a base is always going to be modifiable based on the change in circumstances. The general proposition. Alimony operates a little bit differently. Depending on the language in your property settlement agreement, it may be modifiable, it may not be modifiable. So your first step is going to be to take a look at that property settlement agreement or that order and determine whether the alimony is modifiable or is non-modifiable. But what I would say is, even if the language in your property settlement or agreement indicates that it's non-modifiable, it's still a good idea to consult with an attorney. There is some tension between contract law versus once you have a final judgment entered in a divorce, typically your property settlement agreement will be incorporated and become a part of that order. And that order tends to apply the law. So the statute would apply. So I can tell you in New Jersey, for instance, under the statute, alimony obligations are modifiable based on a showing of a change in circumstances. So, judges operate very differently from jurisdiction to jurisdiction and even from county to county. And so some judges may look at that and may say, well, you have a contract that you entered into, we're going to view it that way. But there are judges and there are courts who may look at the argument that this is incorporated as a court order right now. Whatever happened may have been unforeseeable. We're living right now through COVID-19. Arguably, that was an unforeseeable event that you could not have predicted at the time you entered into your agreement. So even if the language says it's non-modifiable, I would still consult with an attorney.